former President Donald Trump's legal battles pile up. The list goes on in Washington, Georgia and New York. But even if all these cases end in his favor, lawyers say a new legal challenge could still push him aside. This disqualification claim is based on Article 3 of 14th Amendment the U.S. Constitution. This article says that a public official is ineligible to hold public office if he starts a rebellion or provides aid comfort United States their enemies unless amnesty is granted by a two-thirds vote of Congress. Advocacy groups have long argued that Trump's post-2020 election behavior fits these criteria. The debate took on new life earlier this month when two members of conservative Federalist Society, William Baude and Michael Stokes Paulsen, endorsed it in the pages of Pennsylvania Law Review. Lindsay Dedario: if the public records are correct, the case is not even close. He is no longer fit for the office of president, the article says. Since then, two more legal experts, retired conservative federal judge J. Michael Luttig and Harvard law professor Emeritus Laurence, have made the same claim in an article in The Atlantic. The disqualification provision operates independently of any such criminal action, and indeed impeachment proceedings and congressional legislation. They wrote, "This article is designed to be applied directly and immediately against those who betray their oaths. The Constitution, whether taking up arms overthrow our government or by declaring war on our government attempting disrupt the presidential election with a bloodless coup d'état." The controversy even came to the fore on the Republican presidential debate stage in Milwaukee this week. Arkansas Governor Asa Hutchinson said, "More than a year ago, I said that as a result of what happened on January 6, Donald Trump was morally banned from being president again. More people, including conservative legal scholars, understand the importance of this." A mix of cheering and booing emerged from the audience. "I will not support anyone convicted of a serious crime or disqualified under our Constitution." Bode and Paulsen argue that their theory is self-working. They say this means that popular election officials don't need special permission from legislators to disqualify Trump from voting if they believe the claim is valid. They can disqualify potential candidates on their own. Not only that, but academics argue that election officials should legally do so too. Bode and Paulsen write no official should shy away from these duties. It would be wrong to forego one's responsibilities to faithfully interpret, implement, and enforce Chapter 3. In fact, it would arguably be a violation of the constitutional oath of office. Evelyn Hockstein Alternatively, ordinary citizens can appeal to state election officials themselves on the same grounds. Both scenarios are almost certain to face legal and political backlash, and debate could land before the U.S. sue.